Well, the Independent Electoral Commission says it's received and cleared 290 objections of the investigations and deliberations. Now, objections included anything from irregularities or inaccuracies in the counting of votes, the conduct of election officials, and issues to do with ballot papers. Political parties will also have 7 days now to approach the Electoral Court should they wish to lodge a complaint or appeal the final elections results. What else should we think about? Let's bring in our guest, legal analyst, advocate Modidima Mannya, who joins us now to explain what happens when objections are reached and many other electoral considerations, I beg your pardon. Advocate Mannya, it's always great chatting to you. Thank you so much for making time. We also learned this week that there's actually a difference between a complaint and an objection. As a start, are you able to clarify these differences for us?
Yes, good morning and good morning to your viewers. A complaint would typically relate to non-compliance with the code, and it's more of a conduct issue. For instance, this person was prevented from voting under the following circumstances. The objections would be directed at the outcome to say, but this outcome cannot be in the following circumstances.
Sure. It's also interesting then, with that in mind, that the IEC also announced this week that they actually have provision to deal with objections after announcing the final results. It's a bit counterintuitive because what happens in a context where an objection is successful and therefore has a bearing on the outcome of the election itself?
Well, maybe firstly we must understand the structure in its entirety. Remember, we have various functionaries within the Electoral Commission. The Chief Electoral Officer does certain things, takes certain decisions, which the Commission itself can consider, can confirm some of the decisions, it can reverse some of the decisions. So in that context, we need to understand who are supposed to do what and who are supposed to oversee who are supposed to do that. So in that context, it is always proper that decisions be taken, the process be exhausted, before you can then say, I will deal with this or that. So it's not, it's not counterintuitive to say, let me first deal with the objection before I make a decision. At some point, the Commission has to make a decision, the Chief Electoral Officer has to make a decision, the presiding officers have to make a decision. So the scheme is designed in such a way that each of the various actions and steps are supervised.
Sure, I'm not sure if I follow you, and apologies if you've already mentioned this, but what I understood the IEC to have said is that they can announce and proclaim the results first before dealing with all the objections. Is that also how you understand it?
Yes, right. Because the IEC runs an election and there must be an outcome, and you can only object to what has been decided upon. It does not detract from the fact that certain of the problems that are identified are not addressed. I think we shouldn't understand it in that context.
I see.
If, for instance, you were to present yourself to a voting station and you had a difficulty, that difficulty will be addressed there if it's a matter that can be addressed at that level.
Okay. We've also heard that there were 290 objections. However, interestingly enough, the IEC also saying yesterday that these have been cleared. That's literally all the information you have. What do you understand that statement to actually mean? Does that mean, according to the IEC, that all those who had an issue with this election are now satisfied with the outcome of their investigation?
No, it doesn't mean that.
Right.
It simply means that the IEC has considered whatever objections have been placed before it, and it has taken decisions. Now, if people are satisfied, the matter ends there. If they are dissatisfied, then there's a next step, which is to approach the court.
And that's the other part that's, I guess, a bit confusing, because we also heard yesterday that the NFP is considering taking the IEC to court because of these results. However, they appear to be going to the Pietermaritzburg High Court and not the Electoral Court. Is that because of a lack of understanding on their part, or is that also a viable legal option?
No, that is what the law actually provides for. Maybe just to explain the structure, the Electoral Court, for lack of a better word, is the special court which supervises the Electoral Commission. It has, however, specific things that it must do itself, but it has also made rules which define under what circumstances and on what issues you can approach any other court. So even the magistrates court, by the way, has jurisdiction on electoral matters. So if, for instance, an issue were to arise, an electoral issue were to arise in a particular magisterial district, you can approach the magistrates court in that district.
The difficulty, of course, is that, for lack of a better term, life goes on in the interim. Are there any cutoff points for when these outstanding issues can finally be resolved in a context where, of course, they might have a bearing on the outcome of this election?
Look, if you approach the electoral court, the act is very clear, and there are various categories of timelines. For instance, if you are unhappy about a decision of the Electoral Commission and you want to appeal or take it on review, you have to do that within 3 days of the decision. And the Act is very specific and the rules are very specific that these matters must be dealt with inherently on an urgent basis. If you were to approach a normal court, a magistrate court or a high court, you would have to canvass the basis on which the matter must be dealt with on an urgent basis. So it's not as if there's no remedy in the event that matters are urgent. But if you look at the scheme of the Electoral Act and the rules of the Electoral Court, it envisages that these matters must be dealt with as expeditiously as possible.
It's also quite interesting once you look at how many objections there were in relation to how many people actually contested this election. I mean, this is, according to the IEC, in fact, the most competitive election that they've had to conduct. I presume we shouldn't be surprised that there were also so many objections that the IEC has had to deal with.
Yes, definitely. I think one of the things of context in this election, firstly, is that this was probably the most emotive election since 1994. But it also happened in the context that the IEC was testing some of the new technologies.
Right.
And as you could have seen in the campaign, you know, the common trend has been remove the ruling party. So and there was a perception that the voters will outrightly reject the ruling party. So it is understandable that people would have been very sensitive, would be watching over the little details, and not surprisingly, people would pick up even the smallest issue. That does not, however, mean that every single complaint, every single objection is valid. The Constitutional Court has actually set a test, and they say that you must provide sufficient evidence of any irregularities to prove the materiality. So it doesn't mean that every single irregularity would be material enough to have a bearing on the outcome of the elections.
What is also interesting, I find, is that not only can you take the IEC to the Electoral Court because you have taken exception to the results, for lack of a better term, but you can also challenge the IEC for their interpretation of the Electoral Act.
Yes, the Electoral Act makes provision for the Electoral Court to interpret the Act and any law that is relevant to the elections. But the Act also provides that the IEC itself can approach the Electoral Court for an interpretation. So the final authority on the interpretation of the Electoral Act and laws related to the election is that of the Electoral Court.
Sure. What we've also found, Advocate Mannya, as of this morning with the team here, is that there is a discrepancy between what the IEC actually announced in the form of the municipalities that each party was able to secure a majority in versus what the IEC has published on its website. Now, the complexity here is that it's all out there, and in fact, a lot of media houses are going with what the IEC said on the podium last night. However, we've now received communication from the IEC as of this morning telling us, okay, hold on, we're going to figure out how there's a discrepancy, but in the meantime, please rather use the figures on the website. To your mind, what kind of complexities, if any, does that now create?
Well, you know, you must accept and appreciate that at any given stage there would be errors. And I think the former chairperson of the Electoral Commission has ably put it that this is a very high pressure, high complex project, to run. There's bound to be mistakes. I'm not sure whether it is a mistake that has been made, but bear in mind that there is what we call the party political liaison office, which engages on a regular basis with the IEC. You will recall that there are party agents at voting stations when votes are counted. So the actual results would be known to the parties themselves. So in the event that there is some error about what is posted or what is announced, it may not necessarily mean that the outcome of the election has changed. It may just simply suggest that there was an error in the actual information which was communicated.
Yeah, it's the reporting that needs to change and not necessarily the capturing of those results. Plenty to think about. Thank you very much for helping us decode some of these complexities. Really appreciate your time. Advocate Modidima Mannya is a legal analyst joining us there via our video link. Once again, thanks very much indeed.